Be seated. Ready. For the record, both assistant state attorneys are present, both defense counsel, Mr. Sievers. I'm told we have a verdict. State's ready? Defense is ready?
Yes, sir.
Does either side need time to talk to any of the members from either family? I mean, if you can't handle it, it'd probably be best if you wait to find out what the verdict is out in the hallway.
We have spoken with the family and they understand.
Okay.
It's appropriate, Your Honor.
Defense?
We're all set.
Okay. Bring them out. Please be seated. I'll ask our foreperson again, have you reached a verdict? If you'll please pass the verdict form to the bailiff. Thank you. We'll let the clerk publish the verdict.
In the Circuit Court of the 20th Judicial Circuit in and for Lee County, Florida, criminal action. State of Florida versus Mark D. Sievers, case number 15 CF 673B. Verdict form, penalty phase. We, the jury, find as follows as to Mark Sievers in this case. A. Aggravating factors as to count 1. We, the jury, unanimously find the state has established beyond a reasonable doubt the existence of the capital murder was committed for pecuniary gain. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. If you answer yes to at least one of the aggravating factors listed, please proceed to Section B. If you answered no to every aggravating factor listed, do not proceed to Section B. Mark Sievers is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole. B. Sufficiency of the aggravating factors as to count 1. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. If you answer yes to Section B, please proceed to Section C. If you answer no to Section B, do not proceed to Section C. Mark Sievers will be sentenced to life in prison without the possibility of parole. C. Mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. No. Please proceed to Section D regardless of your findings in Section C. D. Eligibility for the death penalty for count 1. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt in Section A outweigh the mitigating circumstances established in Section C above as to count 1. Yes. If you answered yes to Section D, please proceed to Section E. If you answered no to Section D, do not proceed. Mark Sievers will be sentenced to life in prison without the possibility of parole. E. Jury verdict as to death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A, that the aggravating factor or factors are sufficient to warrant a sentence of death in Section B, and the aggravating factor or factors outweigh the mitigating circumstances in Section D, We, the jury, unanimously find that Mark Sievers should be sentenced to death. Yes. If your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. Dated this 10th day of December in Lee County, Florida.
Either side like the jury polled?
Yes, please.
One moment. I'll start with you, our four-person, your juror ID or number or your initials, please. Is that verdict, ma'am, that, do you agree that at least, excuse me for a minute, do you agree that each of the findings in the verdict form is yours? Sir, your name or initials or ID number? Each of the findings in the verdict form is yours.
Yes, I do.
Ma'am, your name, initials, or ID number? Do you agree that each of the findings in the verdict form is yours?
Yes, I
Ma'am, your name or ID number or initials? Do you agree that each of the findings in the verdict form is yours? Ma'am, your name, ID number, or initials? Ma'am, do you agree that each of the findings in the verdict form is yours?
Yes.
Ma'am, your name, initials, or ID number? Ma'am, do you agree that each of the findings in the verdict form is yours?
Yes.
Ma'am, your name, initials, or ID number? Do you agree that each of the findings in the verdict form is yours? Ma'am, your name or ID number or initials? Do you agree that each of the findings of the verdict form is yours?
Yes.
Sir, your name, ID number, or initials? And sir, do you agree that each of the findings of the verdict form is yours? Sir, your name, ID number, or initials? And sir, do you agree that each of the findings in the verdict form is yours? Ma'am, your name, ID number, or initials? And ma'am, do you agree that each of the findings in the verdict form is yours? Ma'am, your name, ID number, or initials? Ma'am, do you agree that each of the findings in the verdict form is yours?
Yes,
Anything further with the jury from the state?
I do. No, Your Honor.
From the defense?
No, sir.
You're going to leave with my thanks, the thanks of the court system here today, and I really appreciate all the time and effort you've put into this case. You've been here for weeks, and it's a lot to ask. It's a lot to ask for a case of this type as well. You are free to talk about the case with anyone you'd like to. You're free to refuse to. If you need anything from the clerk, you can contact their office saying that you've been here this long, and you're going to leave with my personal thanks as well. Have a good night. Please be seated. We're going to have a Spencer hearing. How much time do you need to prepare a memo, State?
It's a couple of weeks, Your Honor. Is that possible?
Defense?
Well, Judge, I've talked it over with co-counsel prior to the verdict. I believe Mr. Sievers would be entitled to a PSI. So we'd be asking for one of those, and we would agree with the state that we need a couple of weeks.
2 weeks?
I don't know if they can generate a PSI that quickly, but
I think they can do that if we need to. Let me take a look at what we got. How much time will you guys need on that date?
Your Honor, at most 2 hours from the state.
2 hours? Roughly the same, or
roughly the same.
how about December 30th?
Your Honor, I unfortunately am not in town from December 27th to January 2nd. apologies to the court, but
Any other time constraints from the state other than those dates?
No, Your Honor.
Any from the defense?
On December 30th?
Well, I'm just trying to figure out, since they have time constraints from the 27th to the 2nd, if you guys have any before I give another date, and if they had any other constraints.
Laura, can you, while they're, may I just walk outside the well for just a moment?
Sure. We could always do the week before, I guess, right? You guys prefer January 9th or 10th?
Days of the week.
Those are Thursday and Friday.
The state would prefer January 9th, but we'll make either work.
Either of those are fine.
You,
That's
you
the
guys have something with Judge Porter, don't you?
Scheduled for Monday the 13th.
The 13th? The 9th work?
Yes.
9th at 8:30, and does either side need to check with the family members to make sure that's acceptable for anybody else who needs to be here?
I already checked with the family, Your Honor, and that's fine.
Do you need a moment, defense?
Yes, please.
Yes, sir.
That's fine.
Okay. January 9th at 8:30, and we'll order a PSI and get your memos before that date in. Preferably, how about we say no later than, was Mr. Hunter preparing that, or is you, Miss Ross?
Probably
believe-
collaborate.
Okay.
Probably Miss Ross, she's better at
So
it
you're gonna
than
be
I am.
gone, you wanna say at least the 8th then? Well, I'd like it a little more than one day. Can you do it by the 6th?
Absolutely, Your Honor.
Okay, January 6th, I'd like the memos due to my office. Anything further from the state,
No, Your Honor.
from the defense?
No, sir.
We'll see everybody then.
Does the defendant need to be printed again?
You're asking for them to be printed today as well?
I'm asking the court, if the court wants another set of prints. We don't need another set of prints from him.
Well, he already adjudicated him guilty at the last stop and took prints, so
Yes, he did.
I think we should be all right until the sentencing.
Yes.
But in the abundance of caution, if you think we should take prints, I'm more than happy to do so.
No, Your Honor.
Okay.
You did adjudicate him guilty last time.
Okay. Do you need some time with him?
Yes, sir.
Okay, if you'll hold on to him in the back for a bit. We'll be in recess.